The Supreme Court just dropped its new decision, a 6-3 ruling today, in the blockbuster Fourth Amendment geofence case, and this is a very critical decision, and it impacts digital privacy, and it also completely reshapes the Fourth Amendment and how it's applied to the digital privacy issues right now in the modern age. In a huge ruling, the Supreme Court has officially decided that the government cannot use a digital dragnet warrant to spy on everyone in a specific area without actually having a specific suspect, declaring actually once and for all that accessing your location and looking at that type of history is actually a Fourth Amendment search and violates the Constitution. This case asked and addressed a critical issue. Can the government issue a single warrant to identify every single person in a location all at once, even if they have absolutely no idea who the suspect actually is? Today, the Supreme Court stepped in and drew a very critical line in the sand. So let's break down what actually happened in this ruling, how the Supreme Court actually split on this issue, and what this means going forward for your privacy in this type of digital age issue. Now, before we jump into the mechanics of this ruling, if you like this type of content and you want to make sure that you get it going forward, make sure you subscribe and also turn on the notification icon to ensure you never miss these videos when I release them. Now, to understand why today's ruling is so massive, we have to look at the facts of this case, which is Chachri versus the United States, and essentially what led this case to eventually make its way all the way up to the Supreme Court. So essentially back in 2019, police were investigating a bank robbery in Virginia. They had zero leads and no actual known suspect at the time. All they knew from surveillance footage was that the individual here appeared to be talking on a cell phone near a church, which was next to the bank. Instead of building a case against a specific person because they had no one, law enforcement did something different. They went to a magistrate judge and got a geofence warrant, which was directed at Google. They demanded the location data for every single device within 150 meters in that radius of that bank and actually within that church area as well. And they set it for a specific time frame of that robbery. This was a broad warrant trying to get all the data of everyone within that area for that time frame and within that certain geofence data that was requested of Google. Law enforcement actually went through a 3-step process with this geofence warrant. First, Google handed over anonymous location data for all 19 cell phones within that 150 meter circle. Second, law enforcement looked at the data and ordered Google to give them an expanded 2-hour window of tracking data, both inside and outside that geofence location, for a narrowed list of 9 people. And third, they narrowed it down further, forcing Google to unmask the actual real names, emails, and phone numbers of 3 users, one of whom actually ended up being Mr. Chachri. Based entirely on working backwards from that digital dragnet through the geo warrant, Chachri was identified as the individual, arrested, and convicted of the robbery. The data the government took is called location history, and as Justice Kagan wrote in the majority opinion, over 500 million people worldwide have this type of location data enabled. Google prompts you constantly to turn it on, and sometimes it actually warns you that your phone won't work correctly without it. Once it's on, it logs your location every 2 minutes, accurate potentially within 20 meters, and can even track your elevation to know exactly what floor of a building you're currently standing on. This is kind of an all-encompassing digital diary of your entire life, which is tracked through Google. Now, in this case, the government tried to argue that this was not a search under the Fourth Amendment. They claimed that because it was only a short-term monitoring, about 2 hours of data, and because users voluntarily share their data with Google, the police did not need to clear strict constitutional hurdles. However, on review of this case, today the Supreme Court disagreed with the government in their 6-3 ruling. Writing for the majority, Justice Kagan flatly rejected the government's arguments. First, the court officially extended the landmark Carpenter versus United States ruling to location history here in this case. Kagan noted that the location history is even more precise, granular, and invasive than the cell phone, site data protected in the Carpenter case. Second, the Supreme Court crushed the government's excuse that short, 2-hour windows here didn't count as an invasion of privacy. The majority noted that the Fourth Amendment does not have a grace period for surveillance. She said that the Constitution makes no exception for police officers who maybe just barely crack open your front door. They stated that a short-term search can still reveal a lot and can still violate your fundamental constitutional rights under the Fourth Amendment. Third, the court dealt a massive blow to the third-party doctrine, which was argued in this case. The government claimed that by using Google, you forfeit your privacy rights. The majority in this ruling said absolutely not. They stated that carrying and using a phone here is an indispensable part of participating in modern society, and opting into an app's features is not a voluntary waiver of your constitutional rights, and you're not just simply waiving that to the federal government. Now, here's the critical twist that you need to understand for this case. The Chatry case is not entirely currently out of the woods yet. While the Supreme Court ruled that this was a Fourth Amendment search, that this was a violation here, they did not formally throw out his conviction. Instead, they vacated the judgment and sent this case back down to the Fourth Circuit to re-review in light of their new ruling. Now, also in this case, the way that the Supreme Court split also tells us everything that we need to know about potentially future digital privacy cases and, potentially those other types of issues when they make their way to the Supreme Court. Now, on one block of the Supreme Court, you kind of had the privacy hardliners where you had Ketanji Brown Jackson, who was joined by Sotomayor, and they wrote a concurrence warning that multi-step geofence warrants are incredibly dangerous. They argued there in the concurrence that steps 2 and 3 gave police this roving commission to bypass the magistrate and act as a judicial check only on themselves. Now, you also had a concurrence written by Justice Gorsuch, which kind of took a more originalist approach. He essentially said that he would argue that you should kind of bury and get rid of the old cat's expectation of privacy test, and he wants to do away with that entirely. Gorsuch argued and stated that the digital location here in your history data is literally your personal property, and it's your digital effects under the text of the Fourth Amendment, and that the government has no right to trespass against that property. Now, you did have a dissent from Alito, who was joined by Thomas and Barrett, and they kind of dissented fiercely against the majority. Alito blasted the majority for issuing what he called an advisory opinion on an obsolete technology, warning that this ruling will send seismic waves through criminal law and destabilize law enforcement's ability to solve these types of hard crimes. He also noted that a July 2025 Google update already moved location history on the device, essentially making the corporate database mostly immune to these types of warrants anyway. So in essence, the dissenters also argued that this specific technology may not be in use going forward anyways, and because of that, they believe that they should not have issued a ruling in this case. But make no mistake with this ruling, with today's ruling, it's a massive line in the sand against digital surveillance and what impacts it currently has on the Fourth Amendment. Potentially the era of the government executing a digital general warrant to search everyone first and establish probable cause later just hit a constitutional wall with this 6-3 ruling. So let me know what you think about this ruling. Do you think that the majority got this correct? Do you think that they issued the correct ruling, or do you agree with the dissent that essentially this will hinder law enforcement and that this is not a violation of the Fourth Amendment? Let me know your thoughts and comments down below. But if you like this type of video and you want to ensure that you get these updates going forward, because right now we just got a ton of decisions from the Supreme Court impacting a lot of things, and we're going to be breaking down those as we go forward, make sure you like, comment, subscribe, and also make sure that you turn on the notification icon so you get those videos and those updates when I release them. But as always, thank you guys so much for all of your support, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.